Welcome, everyone. Thank you for your time and attendance. My name is Richard Shannon, Executive Officer of the NFF Horticulture Council, whose members you can see in my background. We're especially glad and grateful to have Mick Keogh here with us, Deputy Chair of the Australian Competition and Consumer Commission, and also the Agriculture Commissioner, to deliver the second of a two-part series on codes of conduct relevant to the horticulture industry. The first in that series was focused on a horticulture code of conduct, and this second on the food and grocery code of conduct. I suppose just a couple of comments on behalf of the council to kick us off. Competition rules and trade practices are a really important part for our industry, and the council has decided that there is a role to be played in terms of raising awareness of these codes, both within the grower community, but also with those with whom we trade. And so really appreciative of commitment from the ACCC and also Mick to this two-part series. They will be recorded and available elsewhere. I might stop there and hand over to Mick, who will run us through a presentation, and I understand there'll be time for questions at the end, should there be some left. Over to you, Mick.
Thank you very much for that introduction, and thanks for the opportunity to talk about these issues, particularly the codes. And there can be a bit of confusion about what code applies and what the implications are of different codes. So I think it's very useful to go through that. So I'm going to probably spend 15 to 20 minutes just going through the food and grocery code, and hopefully that'll give you a sense of how it operates and what the key obligations are under that code and how dispute resolution works, and obviously what our role is. That is the ACCC's role in relation to that code. In contrast to the horticulture code, which is a mandatory code, which means anyone who fits the definition spelled out in that code has to comply with it. The food and grocery code is a voluntary code. It's a prescribed voluntary code. What that means is that the parties that it applies to, particularly the retailers, can choose whether or not they become signatories. Once they become signatories, they're bound by it and required to comply with it. And we can, to a limited degree, take enforcement action associated with it. But if they don't choose to comply with it, become a signatory, then they're not bound by it. It was introduced in 2015 in response to a number of issues that arose around that time. Some may recall the ACCC took action against both Coles and Woolworths for two different sets of activities where I think in summary it's best described as they were leaning on suppliers to make extra contributions and improve their bottom lines. And in the Coles case, it was settled with Coles admitting to their behaviour, and that ended up with a process set up involving Jeff Kennett, where the suppliers affected by that were recompensed. In the Woolworths case, we were not successful. That was the Mind the Gap case. But I guess in response to that sort of behaviour, that's where the code came from. It basically gives some extra protection to suppliers in their dealing with retailers. And I think that's the best summary I can make of it. I'll just take you through some of the details. But just to clarify, in relation to the relationship between a grower, for example, and a wholesaler, for example, operating in the wholesale markets in each of the capital cities, that relationship is covered by the Horticulture Code, and that's a mandatory code. There's not a requirement for, or there's not a code that applies in relation to the relationship between a wholesaler and a retailer. But where a grower is supplying a retailer direct, then the Food and Grocery Code applies, as it does for any other suppliers of retailers. So that's the code we're talking about today, not the Horticulture Code, which we talked about in the last session. So the current signatories of the code are Coles, Woolworths, Aldi, and Metcash. So that means they've all agreed to be bound by the code. And then suppliers who supply them are automatically covered by the requirements of the code. So let's go on. What does the code do? It has these main 7 requirements in it that basically set out how the code operates and works to help protect suppliers in that relationship. Firstly, as is the case in many codes, it has a requirement for the parties to act in good faith. So that's a broad general provision which basically requires the parties to deal with each other honestly and to a degree fairly. It's not something that's been fully tested in the courts. It's not well defined, but it's certainly a reflection of some concepts that are available under common law, and is certainly it sets out some of the factors that can be taken into account in relation to that. So acting honestly, acting fairly, not causing undue harm, etc., etc. So that's a general provision. The code also includes some detail around requests by suppliers for price increases to be agreed to by retailers. So it requires that the suppliers request those price increases in writing, and then it requires that the retailer will notify the supplier within 30 days whether they accept the price increase, whether they want to vary that price increase, or whether they won't accept the price increase. Depending on the outcome of that, the supplier can then, under the code, request negotiations about the price increase. Delisting is another issue dealt with by the code. Under the code, the signatory, that is the retailer, can only delist the supplier's grocery product in line with the terms of the agreement. So typically the issue there might be that the product's not performing, for example, and sales aren't achieving targets, in which case there is a genuine commercial reason for that. They generally are required to give a written explanation if a delisting does occur, and delisting as a punishment for a complaint or something of that nature is not a genuine commercial reason. So it's not a reason for delisting under the code. And of course, there is a review process for delisting under the code as well. So the supplier can ask for a review in the case that a product's been delisted. Payment terms, the grocery supply agreement, which is a requirement for the agreement between suppliers and retailers, has to be in writing, and it should set out the payment terms that are applied to the arrangement. So suppliers should have a clear indication when they can expect to be paid and on what basis. It, for example, requires that there cannot be a retention of money for example, wastage that occurs within the store, or funding for promotions that hasn't been part of the agreement. So there are some parameters that limit the extent to which the retailer can vary the payments that suppliers expect to receive. The grocery supply agreement should also set out the standards and quality specifications for fresh produce in particular. What the standards are, how they will be applied, and those should be in writing. And if a retailer rejects the produce because it does not meet the relevant standard, they must provide the supplier with a written reason for that within 48 hours. As I said, the grocery supply agreements are the basic agreement between a retailer and a supplier. They're required to be in writing. They're required to comply with the provisions of the code, and they're also required to include all associated documents associated with the agreement. For example, freight agreements, promotion agreements, purchase orders, requirements, supplier portal documents, etc. So they all must constitute part of the overall agreement. One of the important parts of the Food and Grocery Code is the dispute resolution provisions. So if a supplier has a dispute, they can raise it with the retailer or wholesaler directly, but they can also raise a complaint with the signatories code arbiter. So each of the signatories to the code, as part of their compliance with the code, has to appoint a code arbiter. Now, in the case of Coles, that's Jeff Kennett. In the case of Woolworths, it's Helen McKenzie. In the case of Aldi, it's Bronwyn Gallagher. And in the case of Metcash, it's Martin Shakanowski. So their role is to receive complaints from suppliers, to gain some understanding of that complaint, and to see if some resolution can't be reached. If suppliers are not happy with the outcome of that, they can ask the independent reviewer, so it's Chris Lefpos, to review the process the code arbiter used in terms of resolving that dispute. So there is an appeal, if you like, to an umpire if suppliers don't think the code arbiter, which is appointed by each of the four signatories of the code, undertook the appropriate processes and reached a decent outcome. And you can also seek mediation or arbitration of the dispute, and that can be, if the grower or supplier wishes, supported with legal advice at any time. The aim is, of course, to have this as a quick and relatively low-cost mechanism to resolve disputes without the need to resort to court processes, which, of course, can be very expensive and time-consuming, and ultimately usually don't end up very well in terms of the supplier being able to afford, for example, the legal fees and the costs associated with that. So that gives you a basic idea of the provisions of the code. As I said, the code is a voluntary code in that retailers don't have to sign up to it. Those that do agree to be bound by it. It's also subject to a series of reviews. So in 2018, Graham Samuel, for example, conducted a review of the code. The outcome of that review was that the code remained voluntary, and that has some implications in terms of, for example, the ACCC's ability to prosecute breaches of the code. So because it's a voluntary code, it doesn't have any penalty provisions associated with it. We can, if the need arises, take one of the signatories to court for a breach of the code. The only potential outcomes out of that would be a court enforceable undertaking that in future they comply with the code. So in other words, we can't achieve a penalty as a result of that there may be the opportunity to take a non-code litigation in the event that, for example, the failure of the retailer to comply with the code amounts to a misrepresentation because they claim that they comply with the code. But that's probably not a straightforward process. So it is important to understand that. But as a consequence of the code being voluntary, that's the situation in relation to enforcement. The 2018 review also rearranged to some degree the role of code arbiters and appointed the independent reviewer, and that has provided an extra layer of oversight over that dispute resolution process. There is a review about to start, or may have in fact actually commenced, about the effectiveness of the dispute resolution provisions. And I know Chris Lefhoss, the independent reviewer, has expressed a view about the extent to which he thinks the dispute resolution provisions are working under the code. So that's a process that's underway. And the October 2023 review will look at some of the remaining provisions of the code. So it is subject to a degree of ongoing scrutiny in terms of its effectiveness, and those involved may be aware of those processes. So as I indicated, we're responsible for enforcing the code. We certainly have powers to conduct regular checks to ensure compliance, and we do that. So to do that, we would issue a demand or an information request to signatories of the code and require them to furnish, for example, copies of their grocery supply agreements so that we can check those. As indicated already, our ability to seek penalties for breach of the code is limited, but we can take some limited court action, for example, to require compliance with the code, and those sorts of things. So it's to some degree limited from our perspective, and that's one of the reasons why in any of the reviews of the code that have occurred, we've sought that it should be made a mandatory code, similar to the horticulture code. And in that case, as we can take action. For example, we took action against Matolo for a breach of that code and achieved a significant penalty. We've also taken action against other wholesalers under the horticulture code and had a penalty imposed there. And we believe that's important in a sense that it creates a deterrent to behaviours that are breaches of the code. But as I said, it's not available under the current food and grocery code in the same way that it is under those other mandatory codes. We do have quite a deal of guidance about industry codes on our websites. We recognise that growers in particular and smaller scale suppliers don't have access perhaps as readily as others to legal advice. So we do make a fair bit of effort to make sure we've got some reasonably understandable advice about codes on our website, and certainly have a look at that if you've got any questions. We can also respond directly. Some of our staff are available and can help in responding to the code, or ASBEFIA, the Australian Small Business and Family Enterprise Ombudsman based in Canberra, is also familiar with the code and can respond to questions. It's probably worth pointing out we're not a dispute handling body in the sense of being able to pursue individual disputes. That's really the role of the code arbiters. We can, in a situation where there's, for example, systemic behaviour affecting a lot of people, we can pursue that, and that's some of the work we do. But when it comes to individual disputes, the first port of call obviously is the arbiters and then the independent reviewer, and that's really the avenue that's available. So look, that's given you a somewhat brief and very hurried overview of the code. So I'm happy to take questions if there's any, and go into some more detail if people would like.
Thank you, Nick. Please raise a hand if you've got a question. Otherwise, we'll also take them through the chat. I have a hand up from Rachel McKenzie, I take it.
Thank you. Thank you, Mick. Good to see you again. Still working on these issues, I see. And probably my question is a bit of a rhetorical one, but do you think that has actually changed anything in the system, having this code?
Look, certainly the feedback that has been obtained by the Food and Grocery Council in their surveys of suppliers points to improved behaviour by the major retailers. Some to a lesser degree than others, but certainly the outcome of their surveys has been a general sense that retailers' behaviour towards suppliers has improved. Whether it's improved enough and whether it's improved due to the code or whether it's improved to those earlier court actions that the ACCC took, for example, and the penalties achieved in that, it's a little bit difficult to know. Chris Lefpos, as the independent reviewer, I think has concluded that there is benefits associated with it, although again he has identified some limitations, and he also did a survey of suppliers, and they certainly pointed to some deficiencies that they felt still applied. So I think Rachel, the report card is a bit mixed. I think.
Thank you, Mick.
In general, there's some positive signs, but I think there's still a lot of concerns by suppliers that they're not convinced are being addressed by the code.
Yes, I think that would be accurate in terms of my assessment as well. I think also, I am hearing reports that growers are being, continually sent letters sort of saying things like, we understand that the cost of production has gone up, but unfortunately, with the cost of living crisis, we are not actually going to increase our prices back to you. And in fact, we are asking you to look for cost savings. And then you find out that the profit margin on the fruit and vegetable produce is quite extraordinary. And I guess, in your view, is there anything we can do about that?
No, that's quite a difficult issue, and certainly probably the most common response we get from suppliers relates to the responses they receive in relation to requests for price increases. We did have a very close look at one of the retailers and how it was managing those requests for price increases, and that was from the perspective of whether they're being honest with their suppliers in response. That matter was eventually discontinued. We didn't think there was enough in it to be able to take any action, but certainly I'd agree with you. The most common feedback we get from suppliers relates to their inability to get what they consider is a fair approach taken to requests for price increases.
Very interesting. Thank you.
Thanks, Rachel. Any other questions before we wrap it up?
I'll ask another one. Sorry. The unfair contract terms have changed recently, haven't, like, not recently in my long experience in horticulture. What additional protections do they provide?
Okay, that's a good question. I think it's quite important. So the unfair contract terms law changed last October. There are a couple of quite important changes occurred. One is the definition of a small business. You may recall that under the previous provision, the whether or not there was a small business involved was determined by the size of the contract. So 300,000 in any single contract or $1 million in a multi-year contract. So if the agreement was for more than that, then the unfair contract terms law didn't apply. So that's now been changed, and there's no contract threshold in the law as it has been reformed. It now applies to a small business, which complies with the ATO definition of a small business, which is less than 10 million turnover and less than I think it's 100 FTEs. Don't quote me on that in terms of numbers of employees. So first, that means it's broadened out much more to a lot more businesses. And for example, the dairy farmers were always uncertain whether their contracts with dairy processors were included with the $300,000 threshold, because of course their milk supply could amount to that amount of money each year. But given the change definition, that would mean they now apply mostly in their agreements with processors. So that's the first thing. The second thing is that it now has a penalty provision associated with it, which means that it's now enforceable by penalties if, for example, a contract has what are considered to be unfair contract terms in it. That provision doesn't actually come into force until October this year. So in other words, businesses were given 12 months grace to review their existing standard form contracts and make any adjustments they felt were needed to ensure that they will comply with that law as of October. So we've certainly made it clear that as of October, we've put out some guidance around that, but as of October this year, we will be in a position where breaches of that unfair contract terms law can entail court processes that would lead to significant penalties. So we've certainly made it clear to large businesses, and that would include, for example, retailers in their standard form agreements, which in a sense would be their grocery supply agreements with small businesses, that they will need to make sure they don't have any unfair and very one-sided terms in those agreements.
Thanks, Mick. That was a question I had following up, was whether grocery supply agreements would fit the definition of a contract or not. And
well, the critical thing is the word standard form contract. So there is some uncertainty around the extent to which individual contracts are varied and therefore constitute other than standard form contracts. But broadly speaking, it seems the onus will be on the provider of those contracts to demonstrate that they're so substantially altered that they're not standard form. So we think it will apply to even contracts where, you know, there's a degree of variation around some of the specifics of them. Certainly if it's used multiple times or a broad template is used multiple times with different suppliers, we understand it's likely to fall under the definition of a standard form contract.
thank you. We are on time and just a little bit over. And without any further hands up or comments, I'd like to just wrap up. And in doing so, thank Mick again for your time today to give us an overview of the Food and Grocery Code. Some contact details there on the screen for relevant authorities, also the ACCC. In the chat, I've put some detail, a link to the independent reviewer website as well. So feel free to be in touch with Chris Leptos as well. Thanks again for everyone's time and attention. As mentioned at the top, this will be recorded, and with the other webinar on the Horticulture Code will be published shortly through NFF channels.
Thanks
Thanks everyone.
Thank you.